Hello friends, in the series on income tax cases, today we will discuss a very important issue which was before the Mumbai ITAT bench, and the issue was that whether the time which is given in third proviso to section 149 for calculating the period of limitation for issuing the notice under section 148 should also be considered for calculating the appropriate authority or for determining the appropriate authority for issuing the notice under section 151, or in other words, whether the proviso to section 151 which has been specifically introduced from 1st April 2023 is retrospective in regard to the reading of the memorandum to the Finance Bill 2023. This issue has been decided by Honorable Mumbai ITAT bench in the case of Albert Joseph Rosario versus Income Tax Officer, International Taxation, and this case is reported in 137 ITR Tribunal at page number 235, and the matter has been decided by Mumbai ITAT bench on 22nd July 2025. In the present case, the notice under section 148A clause B was issued to the assessee on 23rd March 2022. To give the reply up to 18th April 2022, the assessee could not give the reply, and the time as per third proviso to section 149 to issue the notice under section 148 was 26th April 2022, but the assessing officer well before that issued the notice to the assessee on 24th April 2022 and also obtained the sanction on 21st April 2022 from the Principal Chief Commissioner of Income Tax. The matter was before the tribunal, and the assessee was contesting this matter on the legal ground that since the notice has been issued beyond 3 years, so the permission of Principal Chief Commissioner of Income Tax should have been obtained and not from the PCIT. The assessee was also relying on various judgments given by various tribunals, but the revenue argued that the memorandum to the Finance Bill 2023 says that the amendment to the section 151 by introducing the proviso to section 151 has been introduced to clarify the matter that the period according to third proviso to section 149 is to be excluded even for calculating the appropriate authority for granting the approval under section 151. And when the tribunal heard the matter, the tribunal said that in the present case, from the reading of the memorandum, it is very clear that the proviso to section 151 should have been read as having the retrospective effect from 1st April 2021 and not from 1st April 2023. So the tribunal rejected the ground of the assessee that the permission of PCCIT should have been obtained in spite of PCIT, since in the present case the additions were made on the protective basis and the tribunal do not have the information at the time of the hearing regarding the status of the substantive addition in the hands of the wife of the assessee. So the tribunal remanded the matter for fresh adjudication at the level of the assessing officer. Friends, on this issue there are a number of the judgments of the various tribunals and various benches and even the high courts that the proviso to section 151 is effective from 1st April 2023, and from 1st April 2023 the third proviso to section 149 period, which is there for excluding for calculating the period of limitation under section 149 for issuing the notice under section 148, but in the present case a new litigation has started, so it has to be seen in future that what will be the fate of this argument of the revenue and whether this judgment will hold good in future. But this case is against the various other tribunal orders and various high courts orders. At the end of this video, once again I am repeating the name of the case. The name of the case is Albert Joseph Rosario versus Income Tax Officer, International Taxation, and this case is reported in 137 ITR Tribunal at page number 235, and the matter has been decided by Honorable Mumbai ITAT I bench on 22nd July 2025. Thank you friends.